It's a vast crowd.
Well, that'll make it a very intimate conversation. And I thought I would start off and introduce Lee and I. Lee and I lived in Santa Fe, New Mexico. Lee lives in Boston and Toronto. We met 4 years ago at a trust and estate law seminar. And we realized that attorneys were not considering the digital life of individuals after they passed away. My background is in computer science, as is Lee's, and I said, I wonder how many digital assets people have, and is there a problem leaving them on computers after a person passes away? And at that point, I realized there were 3 different considerations from a technical point of view. What are digital assets? Where are they located? What does the law say about these digital assets? And can they be used to commit identity theft? And the answer was, yes, they can. So together, Lee and I began studying this problem of the digital afterlife. What happens to all those records that are sitting on computers? We determined, of course, that they stay there forever unless somebody takes the effort to actually remove them. So today we'll actually talk about the 3 different topics related to digital assets. What technology exists to identify where they are and what should happen to them? And from a security point of view, as an employer, does the employer ever get rid of the digital assets of their employees after they pass away? With COVID, where there were over 3 million deaths in a couple of years, how many computer records about dead people are sitting on corporate files? And does that represent any kind of a risk? And the answer is yes, it does. Secondly, there are laws in place that will allow the fiduciary to treat a digital asset the same way you treat a tangible asset. And then the third thing with regard to digital assets, when people are doing estate planning, writing wills, having trust documents, who is actually in charge of the digital assets and what must be in the legal documents to cover this protection? So, Lee, why don't you take it over from here?
Thank you. Hi, everybody. Can you hear me? Okay. Do you like it better without the mic or with the mic? With the mic? Okay, great. So we're going to start off with talking about digital property and the estate, because most people don't plan about their digital property. They don't think about their online accounts. They don't think about the assets within and the value it might bring to the family or the loved ones they leave behind, the legacy they have, or even deeper sense of technology for educational purposes, philanthropic purposes, even identity theft and security. That's one side of the fence. The other side of the fence is the content providers, the app owners, those who hold identity information. What happens, as Betsy alluded to that? And a third one is actually in between. What happens to the identity of an employee that expenses their cell phone but has records on it that are related to the business and or clients, but is now going to be owned by the family? We're looking at some serious issues with disclosure of information that should never be disclosed. So we have to look at digital property in relation to your state on several different levels. The last one I want you to consider is also businesses. Little known fact, when you sign the terms of service agreements, most of the time you're signing them as an individual, unless you're purchasing enterprise software or using the app for businesses where you identify that you're using that app as a business. You're risking the entire corporation's or business's ecosystem of technology. Recently in Toronto, we had a situation where a marketing company was running 5 websites for its clients. The person who was running the technology died unexpectedly, a young man. And when they went to GoDaddy and they went to DreamHost and they said, okay, we need to transfer these assets and this intellectual property over to the business so the next tech person can run it, they were told no. GoDaddy even went as far as to say to the marketing agency, you're going to have to wait until those domain names expire, and then you're going to have to bid against them in the open market. So if somebody else picks up a domain name for a business, that's money that could be extorted out of the original business, and it can lead to identity and other account information as well. We have to take a look at technology. Technology is moving aggressively. We're looking at assets that didn't exist 10 years ago are now mainstream today. When we think about the blockchain type of assets, crypto, NFTs, and items in the metaverse, not only do they have financial value or emotional value, but they have identity value as well. And technology is ever evolving. And I'm going to pass this over back to Betsy in a moment. But one new asset that's popped up, has anybody here heard of the Shoah project? No? The Shoah project was started by Steven Spielberg. And what it does is you record yourself on a video. This was done for Holocaust survivors through artificial intelligence. They can now have that video projected as a hologram, and it can appear as someone in the room as if you're having a conversation with them. ABBA's on tour using that technology. Roy Orbison was on tour a few years ago with it. The companies have now said, we're going to make it commercially available for in-home. Well, that's great. That's really cool that I'm going to be able to have a conversation with my great-grandkids. But have we thought about what that means for our identity? Because now that hologram and projected image can be used or sold to casting agencies by 2 generations from now of my heirs, and now I could be put into questionable films. I might say something that has a reputational disparagement, and I might destroy my own identity because my heirs had no clue what to do with my digital assets. So we have to look at the whole sphere of not just the asset, but what's the value today and what's the meaning for tomorrow.
When we came up with this idea that the 2 of us would give this presentation, we never really practiced how it would work. So we're playing it by ear. One of the things that's interesting is how many digital assets really do exist. And when I started this off, I thought, well, it's just my email addresses. Well, how many email addresses do I have? I have 4. You may have more. Okay, what about all those contacts in each one of those email addresses? Well, lots of duplications, and that's just email. And then we go to financial. And financial, we have bank accounts, we have credit cards, we have credit unions, we have credit reporting companies, we have brokerage accounts, we have online, we don't have online. And that's financial. Government, driver's license, voter registration, and passports. What is going to happen to all of those digital assets, and who is responsible? If there is a security officer in a company that is maintaining information about an employee, and the employee passes away, who is responsible for securing that information? Does it stay there forever? Does it belong to the company? Does it belong to the government agency? And so now we see government as an issue. What about housing? The housing costs, the rent, the mortgage, and so forth. When you look at this picture, you can see how our world has changed. Everything is electronic. Electronic records are digital assets. Electronic records in of themselves, if they have value, are digital assets. An electronic record that points to a bank account is a digital asset. An electronic record, which is a photo, is a digital asset? And what became very important as we started to study this from a security point of view is that a person's identity was tied to their 200 plus digital assets. Who was in charge of them from a corporate and a personal point of view? So, starting in 2016, the American Bar Association decided there had to be legislation that would define what is a digital asset and who was responsible upon death or disability of managing them, and that person was the fiduciary, the court-appointed fiduciary, the person named in the will or the trust document. And people will say, well, not everybody has wills. That just means that if there is not a will upon death, the court will assign a fiduciary. There is always someone responsible for the digital assets associated with an individual, and that person, by law, in each state, must protect it, protect its value, and if they don't, the heirs can in fact sue them. So you can see, again, some more definitions, the pictures and the videos. Today, there are a lot of times when people want to have celebrations of life. They will want to access all the videos on Facebook or on a person's phone. These are digital assets. Who owns them? The person who created them. When they're no longer here, it's their heirs. Who is going to be able to take them off the phone? That person is named in the will. So there's a whole big connection between what is a digital asset, how many are out there, do people even know where they are? And generally when I give a talk, I'll say to a person, stop looking at your phone. But in this particular case, at this point, I'll say, why don't you look at your phone? And why don't you look at all those apps? And why don't you look at how many digital assets are just associated with you personally, not to mention the businesses that you represent. But there is a very interesting difference between a digital asset and the physical assets. And you can see this on the slide. I won't read it to you. But what is very interesting is that the financial institutions, the banks are required when there is no activity on a particular account to report it. But software companies are not required, and in fact, leave digital assets on their computers. So those pictures that are on Facebook, those digital assets, stay there forever. Have you ever gotten a message that says, wish Carol a happy birthday? And Carol was a friend, and Carol passed away 2 years ago. Who was responsible for taking that picture down and closing the account? And the answer is the fiduciary. But did they know that? Probably not. So let's go.
I'm going to stay here for one moment on the physical property versus digital property. Right now, as Betsy mentioned, custodians, also known as content providers, don't have an obligation to turn anything over as abandoned property. What that means is not only does it live on forever, but if it ever is discovered, it means the estates have to reopen, which means that it's going to go back to the content providers, back to those organizations that have the data in 5, 10, 20 years from now. And people are going to be looking for that information. And has it been sold? Has it been deleted? Does it even exist? So we're going to see a lot more that goes on with technology because technology is expanding. When we think about it, right, we're going to be driving autonomous vehicles soon. We're going to be signing a privacy policy with that. That's a difference between a physical asset and a digital asset. We're going to be signing a privacy policy. We're probably going to have a password to our own car. We already do it to our appliances in our home now. So that Samsung refrigerator has data. That ADT security system, the Ring phone, the Ring doorbell has data. The data is very different than the doorbell itself. So we have to really make sure we transition and transfer data appropriately. And that's very different than physical assets because we don't have control like we do with a physical asset. We know a house, a car, jewelry will eventually be turned over. Digital assets we can't even find. We don't even know it exists, and maybe we even know the account exists, but we don't know how to get the disclosure of the account contents because we're not going in as impersonating the account holder. So we have a lot more levels of issues there. Let me tell you just some of the stories that have actually happened. We have Bitcoin. Who here has not heard of Bitcoin? Okay, because I was going to do a whole nother lecture on that. So a young man, beginning in 2015, I think it was, started a company, thought he was wise, paid himself in Bitcoin. He died, I think it was, 2019? He had accumulated well over the $11 million tax threshold. And his heirs had to pay an estate tax. But guess what? They couldn't get access to the Bitcoin. The family had to sell the house and the car to pay the tax because you can't dispute the tax payment until after it's made. You're looking at memories. 7-year-old girl in England. Her dad died. Family wanted her to know her dad through pictures and video, and because of privacy laws, Apple couldn't release the pictures. It was a 3.5-year court battle with a privacy attorney that finally got to the highest magistrate who gave a court order that protected Apple from any privacy claims. But all the pictures and videos had to be vetted through the privacy attorney. Emotion, expense, but also you have identity issues there too. Then you have Vanguard. This is an amazing one. A financial manager saw the accounts of dead people not being managed, not being open, nobody attending to him. So he just took the money. Here's the amazing part. The only way they found out about it was because his brother-in-law turned him in. He wasn't getting a big enough cut of the deal. Otherwise, it would have went on for years. And then lastly, as I mentioned, business collapse. Who here has heard of Quadriga? Anybody? So Quadriga, it was a crypto exchange. The owner went to India, and he had the only key to the entire exchange. He died while hiking. Everybody lost. The class action suits are numerous. And there's question of whether there was fraud, and the wife ended up giving back everything but $90,000 in a Jeep. So digital assets not only affect the individual, they can affect the company, they can affect the value of the company, they can affect account holders. A lot can go wrong. Thanks. So now we'll talk very quickly about the law. I'll lead into this. So why is this all happening? Why aren't digital assets like physical assets? Several laws are in place to protect our privacy while we're alive, and they remain in force even after we die. So we have the Electronic Communications Privacy Act going back to 1986, really before the internet was really taking off. And it basically says your privacy is priority to any company, and any company that via communications, and that's a very broad definition, that breaches that privacy is liable for a $3 to $5 million penalty per incident. That's why Apple and Facebook and Google can't afford to release information. That's why we have the RUFADA, which is the Revised Uniform Fiduciary Access to Digital Assets Act. That will circumvent the Electronic Communications Privacy Act. So that way, information can get distributed. Now, the interesting part is there's two sides to the fence. It can compel custodians and content providers to turn over information to the estate. The other side of the fence is it can compel custodians to turn over data. And many of the content providers that we're so familiar with don't even have a plan in place to do that. They're innovating, they're creating. So in this case, the law is ahead of behavior, ahead of trends.
In the interest of time, we're going to conclude this presentation about digital assets and the law and invite you to review some of the literature on the topic of the digital afterlife and what you as an employer can do and to consider while you are creating HR benefits for your employees. You might want to also talk to them about protecting their digital assets and also protecting the digital assets associated with the customers that they're working on.
I'm just going to ask, do people want to stay and hear us? Is it okay if we continue?
Okay,
Is that okay with you?
absolutely.
I feel like we're the Smothers Brothers, if anybody knows who they are. Yeah, because if you want to stay, because we're going to talk a little bit about the law, but also how to prep your organizations so they're not caught in between a mess.
Yeah, well, you can go ahead.
So one of the things that most people think about right away is password sharing. Can I share my passwords? Why doesn't that work? Well, there are a number of reasons, and it's also a very dangerous activity or a solution. One is it's against the law. It's against federal and state and anybody from Canada, provincial law. There's laws on the books that prevent a individual from giving out the password. Even though you may be the account holder, Facebook still has to give permission to you to share that password. Technically, you don't own your data. That custodian or the content provider does. And you sign the terms of service agreements that prevent you from sharing passwords. And if your heirs try and they fail, permanent lockout. And in fact, Yahoo went as far as one time to say to a family, if you didn't get the password right, how do we know they didn't change it because they didn't want you to get in? It actually gave them an argument in the court system to prevent the family from getting data. You have two-factor authentication, biometrics, all these other things that come in, and if you don't get it perfect, it's going to look like hacking to one of the content providers. And Google had it happen here in Colorado, where the family tried so many times within the first 24 hours of death, they thought it was a hacking ring, they sent the police to the home. Can you imagine, while grieving, they sent the police to the home? From a custodian or content provider's point of view, they're on alert. They have to protect that data. They have to protect that identity. So we don't want password sharing. And as your organizations become more mature with security protocols and security methods, you're going to see more and more people saying, try passwords. And one more thing, and then I'll pass it back to Betsy. I feel like this is the Betsy and Lee show. Here's a research by the Society of Trust and Estates Practitioners. This is shocking. 2 out of every 4 lawyers, or 50% of lawyers almost, are telling their clients share passwords. 1 out of every 4 lawyers, so 25% of them, are doing knowing it can lead to criminal liability and be ineffective. They're not only placing the estate and the client's assets at risk, they're placing your organizations at risk. So we're trying to educate. Betsy and I do a lot of the shows because we have to educate lawyers and those producing estate plans as to what is appropriate and what isn't. But I can tell you right now, they don't know. Lawyers are unaware. They're just learning about it.
The issue of attorneys not knowing what to do has really interesting ramifications. Right now, we've completed 20 months of research and badgering, if you will, with Apple to get them to allow a user to say, my logon is Betsy.Ehrenberg, but if I am not able to use my account, I can say Lee Proskauer. It took 20 months of arguing with Apple for them to agree that one person could give another name to be able to open an account as of death or disability. It shouldn't have taken 20 months. There's another interesting story about Google. If a person assigns an inactive manager, somebody who can take over their account. So I would say my account is Betsy 97@gmail.com. If I'm not active for 2 or 3 months, I want another person to take it over. And I do that in 2022. But I'm active all the time, and 5 years from now, I'm unable to access my account. If the named person that I put in the account today is no longer around 5 years from now, Google says we will allow no one to access the account because when the person was alive, they named a person, and we are sorry that that person is no longer available. So the contents of a Google account, if a person uses inactive manager, are lost forever. It's a very, very interesting conundrum that is happening right now because we know there's a problem and we want custodians to address it. And
I'm just going to jump in on that.
yeah,
To Betsy's point, Apple took a long time to develop their version of the inactive account manager, and Google has as well. And as Betsy pointed out, if that inactive account manager changes, or I want somebody else to get it, the data is still going to go to the inactive account manager. And guess what? Betsy does that in 2022. And then in 2027, Betsy changes her estate documents to say Lee will get it instead of John. Doesn't matter. The Ayurveda law says whatever's on Apple's books, whatever's on Google's books, that's going to get the preferential treatment and the estate's going to get screwed even though I'm named in the estate plan. How is that going to help your organizations in terms of planning for data? Because those proprietary pages probably will not be updated with changes because if I have 100 of them, I'm going to procrastinate it. The behavior is such that I'm just not going to do it as the account holder.
anyway, we thank you so much for staying here. I know you're missing the reception. We're going to go there as well. And you know how to get in touch with us if you'd like to find out more information about how to protect digital assets. Thank you.